An agency is a business entity that provides service to other businesses or individuals. It acts as an intermediary between clients and service provider, helping clients achieve their goals by leveraging the expertise and resources of the agency. Agency is a legal relationship which exists in employment law, corporate law, buying and selling of properties, land and goods. What is a business transaction? A business transaction is a financial transaction between two or more parties that involves the exchange of goods, money, or service. To engage in the business transaction, the business exchange must be measurable in monetary value so it can be recorded for accounting purposes. Business transaction will affect the financial of the company involved. Business transaction can be as simple as a cash purchase or as complex as a long-term service contract. To be considered a business transaction, the following characteristics must be present. The transaction can be measured in monetary terms. The transaction occurs between the business and a third party. The transaction is on behalf of the business entity and it is not for an individual purpose. The transaction is recorded by authorities legitimate. A document like an invoice, sale order, and many that support that the transaction. A business transaction can occur between two parties for mutual benefit or between a buyer and a customer, such as a store and a person purchasing an item from the store.
Hi, my name is Normazin binti Abdullah Safwan. I will saying 3 ways an agency relationship can be terminated. An agency relationship can be terminated or dissolved in 3 ways. 1. By operation of law. An agency may terminate by operation of law upon the occurrence of the following events, where the party concerned is an individual by death, insanity, or bankruptcy. By operation of law, also where the party concerned is a limited company, which is winding up or receivership. 2. By notice. If the agency agreement provides that the agency may be terminated upon either party serving on the other written notice of a specified duration, for example, 3 months written notice, either party may terminate the agency agreement by serving the required notice on the other party. However, if the agency agreement does not contain any termination provision, the general rule is that reasonable notice has to be given to the other party to terminate the agency. Number 3. Renunciation by agent. An agent is entitled to renounce his power by refusing to act or by notifying the principal act for the principal. Unilateral termination of the agency by the agent before he has fulfilled his obligation under the agency agreement will render the agent liable to the principal for breach agreement, such as payment of damages for loss suffered by the principal.
Hi, how are you? Now my name is Rahimi Shazwa Bileman and I will be represent about the expectation to the demo.co non-habit rules as recognized in Malaysian law. Now for the introduction, the demo.co non-habit rule is fundamental principle in contract law that govern the transfer of ownership of goods. The rules hold that a person cannot transfer ownership or property they do not legally possess. This principle is recognized and applied in Malaysia, which has a common law system influenced by English law. Now, nemo dat non habet literally mean no one can give what they do not have. Is a legal rule, sometimes called the nemo dat rule, that states that the possession of a possession from someone who has no ownership right to it also denies the possessor any ownership title. Now, for the importance in property transaction, the nemo dat non habet rule is crucial in property transaction, particularly is to situation where the transferor acquired the property illegally or lacks clear title, as it protects rights of good faith buyer and maintain the integrity of the property market. It's helped to maintain the integrity of property transaction and deter fraudulent transfer, ensuring that individuals are held accountable for their action. It's also served to protect the interests of both the buyer and the original owner of the goods, and is widely recognized and applied in jurisdiction following the common law tradition. Now, there are three exceptions to the nemo dat non habet rule, which is 1. Estoppel, 2. Sell by a seller in possession after sale, and 3. Sell by a buyer in possession after sale. Now, number 1, it is estoppel. If the original owner makes a representation that they no longer own the good, and a third party relies on this representation in good faith when buying the goods, the owner original may be stopped from denying the buyer titles to the goods. This protects buyers who were misled. On the right side, there are the video that give an example to what is estoppel.
Number 2. Sell by a seller in possession after sale. This exception has been governed under Section 30, Clause 1 of the Sale of Goods Act 1957, in which it simply explained that when the seller has transferred the property in the goods to a buyer but remain in possession of the good, the seller then sells the good to another buyer who buys in good faith. The effect of these circumstances is that the original buyer will lose his title and the second buyer will eventually get the title. The original buyer, however, has the right to seek for the remedy against the seller. Number 3. Sell by a buyer in possession after sale. This exception can be seen in Section 30, Clause 2 of the Sale of Goods Act 1957, in which it can be simply explained as the buyer has been consented by the seller to obtain possession after the contract of sale has been done. However, it has to be noted that the property is still subject to some right and interest of the seller. Such buyer can only pass a good title to another good faith buyer who has no knowledge about the right or interest of the original seller.
That's all from us. Thank you for watching. Bye.
Surat dari ejen serah kau paham.
Sambil tengok kayu.